Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Amendment Bill 2014. To discuss the issue, I have with me Mr. P.S. Krishnan, former member, National Commission for SC/STs, and Mr. Colin Gonsalves, senior advocate. Now for the headlines. The SC/STs Amendment Bill makes discrimination against members of Scheduled Caste and Tribe more stringent. The new proposals provide for jail term for public servants if found discriminating. It empowers the special courts to presume the accused as guilty, onus to prove not guilty on the accused. The government intends to make the Scheduled Caste and Scheduled Tribe Prevention of Atrocities law more stringent and deterring. Government intends to amend the existing law to protect the SC and STs members from deliberate discrimination by individuals and public servants. The new proposals provide for jail term for public servants if found discriminating.
Forcing members from SC or SC community to vote or not vote for a particular candidate will be treated as an offence under the proposed Scheduled Castes and Scheduled Tribes Prevention of Atrocities Amendment Bill. The bill proposes specific procedures to be followed by non-SC/ST public servants in all public offices to protect the rights of Scheduled Castes and Scheduled Tribes.
Decision of the government, and I'm pretty sure that such kind of a law or the proposition was required. It does not mean that there are not good people in the government. There are plenty of good people who are really well-wishers of the government. But because of some of the hard nuts, sometimes the well-being of the Scheduled Caste and Scheduled Tribe get marginalized or get ignored.
Or you want to file against anything, the major dominant caste are the civil society or against the government, there is no space for the victims to file. No public servant will agree. I can say just one small example. We have across the country almost 650 districts. We tried to file one single case with the DMRDC. Not even a single DC has accepted the case.
According to the bill, garlanding any member of the SC or ST community with footwear, compelling them to dispose human waste, or forcing them to do manual scavenging, abusing SCs or STs by caste name in public, or imposing a social or economic boycott, preventing SCs or STs from entering into common properties like public places, education or health institutions, or any other place of worship will be treated as atrocities against SCs and STs. People found violating these provisions will be faced with imprisonment for a period of 6 months up to 5 years with fine. Any person damages any property or commits a crime against a member of a scheduled caste or a scheduled tribe will be imprisoned for life with fine. Any public servant who neglects the duty or refuses to register a complaint or an FIR will be imprisoned for a period of 6 months, which may extend to 1 year.
मेरे बात पता हो ये नागडोर से ये उड़ीसा में भी 10 साल से लगातार वो ज़मीन की बात लड़ते हैं। अब से तो कोई गरीब दलित आदिवासी जाते हैं तो वो सरकार वो तहसीलदार पास जाते हैं वो ज़मीन के घर का पट्टा के लिए। आज तक किसको ये 50 साल से किसी ने एक ये तहसीलदार नहीं सब कलेक्टर जो काम है वो काम करते नहीं। ये सबसे बड़ा दुख की बात है।
The Scheduled Castes and Scheduled Tribes Prevention of Atrocities Amendment Bill 2014 was introduced in Lok Sabha by the Minister of Social Justice and Empowerment, Tawarchand Gehlot, last year. The bill replaces Scheduled Castes and Scheduled Tribes Prevention of Atrocities Amendment Ordinance. The existing law prohibits the commission of offences against members of Scheduled Castes and Scheduled Tribes and establishes special courts for the trial of such offences and the rehabilitation of victims.
Civil society groups across the country are appreciating the government's move to make public servants accountable for their actions against SCs and STs. They want the government to implement the law as quickly as possible. With camera person Smriti Ranjan, Rajkamal Rao, Rajya Sabha TV.
New offences added under the bill include garlanding with footwear, compelling dispose or carry human or animal carcass, disrespecting any deceased person held in high esteem, and imposing or threatening a social or economic boycott. So, very specific compared to the earlier law. Very specific. Do you think it serves the purpose and will help in implementation?
This bill is a substantive step in the right direction of making crimes against scheduled castes and scheduled tribes punishable. There is a novel by Dostoevsky called Crime and Punishment. The story of atrocities against scheduled castes and scheduled tribes is crimes without punishment. Most of the cases have ended in non-conviction, and even where conviction is there, it is after a long time, and only some are convicted. Now, one of the things that is done in this act is, I'll list out 3 or 4 good things done in this act. Number 1, certain crimes taking place against scheduled castes and scheduled tribes, which have been taking place, but which are not listed in the original act of 1989, have been listed here. Some you have mentioned, but I would say extremely important are social and economic boycott.
Yeah.
This is a phenomenon which Dr. Ambedkar pointed out in 1928 to the Simon Commission as taking place. I wanted that you brought into the original act. I failed at that time. Now it has come now here. This is a very, very important social economic boycott is the most crippling thing that we can do to the scheduled castes and scheduled tribes.
So just on that point, how easy is it to bring into the legal framework something like social boycott? Now, how are you going to write or make a mention of that so that the implementation on the ground becomes effective and becomes punishable and convictions can be carried? How easy or difficult is it?
It's actually reasonably easy. I'll tell you why. Take the Mirzpur case, for example, where in Haryana the atrocity took place, people were burnt alive and so on and so forth. Cases were filed against the dominant caste. What happens? Social boycott, economic boycott. What does it mean? You go to buy milk, you can't buy milk. You go to the shop to buy groceries, you can't buy groceries. You go to the field to do your morning absolutions, you can't go to the field. You try and get work in the village, you won't get with it. It's very easy. Social and economic boycott is the principal way in which Dalits withdraw their cases. They can't stand it. They can't get jobs, they can't get employment, their children can't go to school, they'll be boycotted in school. Now, if you write that in your complaint that a social and economic boycott is taking place, and the judge says, okay, I'm appointing a commission to check, and the commission says, yes, sir, they are being boycotted completely in the village, and the villagers think boycott is their inherent right, God-given right to boycott the Dalit community and starve them into submission.
So can you pull up the entire village for it?
Why not? If it's a social and economic boycott by a village, you can punish the entire village. There's a provision in the act for collective fine. Suppose you burn the Dalit houses, the village dominant community burns the houses. Court can impose a collective fine and say a loss is 1 crore. The villagers shall pay 1 lakh each. You can do it. So it's a very powerful act, and it's a powerful act because the atrocities are the worst in the world.
So the social, the second point that you were making, besides the social and economic boycott, the next point that you were making, sir?
Second thing is protection for victims, survivors and witnesses. For want of this protection and dragging on of cases, pressure is brought on them, they are coerced. This a typical example is Kambalapalli, where accused number 1, who was only surviving member of a family of 8 who were killed, burned to death. He turned hostile. And when he was asked, why did you turn hostile to your own family? He said, give me protection, then I shall speak the truth.
See, we'll come to the witness protection.
Same thing happened in Bihar also.
Yeah.
So this is number 2 provision which is there. The responsibility and the duty is cast squarely on the state government and also on the court to supervise to provide protection in all
that
respects.
we will deal in the second segment, sir. The third point, sir, you making.
Next is speedy trial is extremely important. Therefore, exclusive special courts. I wanted that even in 1989, but unfortunately the draft it came as specifying an existing court as a special court, which is throwing dust in the eyes. An existing sessions court being specified as special court doesn't make any difference because it has got the same old burden of cases, and this case will be badly delayed. Every case has been delayed. Batani Tolas, after 12 years we got judgment. The Chunduru we got 16 years judgment. So all these cases are delayed, and delay means most of the cases end in acquittal, though the crime is real.
Got it. On the implementation part, the way you've seen it, the way it has been drafted, and much more specific, very close to being almost there. Will it help in implementation, and what has been the biggest problem in implementation as far as making it punishable is concerned?
I think as far as the provisions are concerned, you cannot hope for anything better. I'm very skeptical about the NDA government and the laws that it makes, but when I looked at this act, I must say I must congratulate the government for what it has done. Will it automatically result in speedy trial? I don't think so. It will depend on lawyers mobilizing and using the law properly. The biggest impediment, according to me, is the caste biases of public prosecutors and judges. And as you go higher up in the hierarchy, when you come to the high courts and above, you will find the representation of Dalit judges very poor.
No, is there representation of enough sufficient number of Dalit judges?
Not in the higher courts and above. Not in the superior courts. In the lower courts, yes, but not in the superior courts. As a result of which, I think, the kind of direction that the Supreme Court and the High Court should give, that Dalits require the strongest kind of protection, is missing in the country. Is missing. And in the superior judiciary, they are loath to think about correct representation in the upper judiciary. Loath to think about it. No, it can't be. Lower judiciary, yes, higher judiciary, no. That, to my mind, is the biggest problem, because we do not have. You have activist judges for women, you have activist judges for environment, but you don't have activist judges on Dalit rights at all. Their voice is silent in the upper judiciary. That's the main problem, according to me. Commitment of the judiciary, the upper judiciary, to implement this statute. That is missing.
Haven't you been hasn't this been an issue for a long time? Why hasn't the system been able to include them in the higher judiciary? Where is the resistance, according to you, administratively or policy-wise or politics-wise or, the mindset of the judiciary? Where is it? Where do we have the problem?
Our caste system and untouchability is so all-pervasive. It enters into your genes. Now, Obama was saying after Charleston that racialism has entered into our genes. Now, our media have given more space for Charleston than for all the crimes that have taken place in our media, which goes into frenzy on many issues, of course with good results in some cases, has no time, no patience, no interest in the crimes that are taking place day to day against scheduled castes and scheduled tribes. For example, in Vachati in 1992, the whole village was demolished as there was enemy action. All their fields were destroyed, their wells were defiled, their women were raped. 1992. And that is a case where maximum number of people have been convicted, including a retired chief conservator of forests, a number of conservators of forests, forest, revenue and police departments, personnel joined together in destroying that village for some matter. Now, this even registration of FIR was a problem there. A court had to pass an order to register the FIR. And after so many years, last year the judgment has come. Now it is an appeal. What will happen, I don't know. So, unfortunately, unless we do, and here it's extremely important that the Prime Minister of the country, party is immaterial for me, the Prime Minister of the country and the Chief Minister, if they take serious interest, atrocities will come to everybody, will fall in line.
I get it. I'll get onto that role, sir, in the next segment. Time for us to head into a break. When we come back, we will talk about provisions in the bill for strengthening of court infrastructure for such cases. Welcome back. The bill empowers the special courts to presume the accused as guilty unless evidence proves it otherwise. The bill also provides for protection of victims of atrocities. The bill fixes the responsibility of making schemes to provide protection to the victims on the state.
The bill has the provision to protect the rights of victims and witnesses. According to the amendments, it will be the duty of the state to make arrangements for protection of victims, their dependents, and their witnesses. The state government will have to specify appropriate schemes to provide immediate relief in cash or in kind to atrocity victims or their dependents. The proposals empower government to seek assistance from non-government organizations, social workers or advocates of victims of atrocities if required.
No, a person who is not guilty will be called by the courts, because if they have to prove that they have not done anything, I am sure the bureaucracy has such a huge, massive paperwork and massive evidences. So any person who is not responsible for violating this code will have enough evidence to prove that he has not done anything wrong.
ये जो दबा जो देने जाते हैं उसको तो ये सपोर्ट देना तो बहुत ज़रूर है, सरकार की जो व्यवस्था है वो अच्छा है। बिल्कुल ये जो उड़ीसा में ये जो 15 साल की नवीन पटनायक सरकार है, ये 15 साल से जो 12,000 दलित ये जो महिला ये रेप हुआ उसमें 10,000 दलित आदिवासी हैं। अब तो ये जो बेबीना बेहरा वो एक दलित लड़की को जो अत्याचार हुआ, मर्डर हुआ, इसमें जितना दबा ये जो साखी था 2-4 को उसको ख़त्म कर दिया। ये जो रेप करने वाला का जो दवांग व्यक्ति है उसका जो बेरेदारी है वो सारे ख़त्म कर दिया। आज तक किसी को ये जो जितना केस चल रहा है अभी कोर्ट में, ये 5 केस में एक केस दलित आदिवासी को ये आज तक ये नहीं मिला।
The bill seeks to establish exclusive special courts (ESC) at the district level to ensure the cases are disposed of within 2 months. Appeals of these courts will lie with the High Court and must be disposed of within 3 months. The bill proposes to appoint a public prosecutor and an exclusive public prosecutor for every special court and exclusive special court. Any complaint relating to harassment of victim, informant or witnesses will be tried separately from the main case and must be conducted within 2 months. Courts established under the bill will presume the accused as guilty unless the contrary is proved on cases relating to atrocities against SCs and STs.
The current judicial system is overburdened, and therefore for them the atrocities against Dalits or their violation of their rights, basically, any kind of criminal activity against them really do not get sufficient attention in the due course of the judicial process. Therefore, we have always been maintaining that government need to create special courts.
The Parliamentary Standing Committee on Social Justice and Empowerment examined the bill and has asked the government to make registration of false cases under the bill as punishable offences. The Parliamentary Committee has suggested provisions to punish those who acquired false certificate to claim reservation benefits in jobs and admissions. According to the report, entering into an intercaste marriage to procure Scheduled Caste or Scheduled Tribes certificate to acquire land or to fight elections must be treated as a punishable offence.
After going through the Parliamentary Standing Committee report, the government and Ministry of Social Justice are considering to include a provision relating to false cases filed under the bill. With camera person Smriti, Rajkamal Rao, Rajya Sabha TV.
In an event where violation takes place, the court shall presume that the accused was aware of the caste or tribal identity of the victim if the accused had personal knowledge of the victim or his family, unless the contrary is proved. Now, this is exactly what has been written in the bill. As it is, we've picked it up. Does this imply that the onus of proof to prove not guilty is going to be on the accused?
No. Because I heard you say that in the very first. It's not a presumption of guilt in respect of the offense. It's only a presumption that you know the caste of the accused. That's all. Namely, you can't say, I didn't know the person was a Dalit. I live in the same village, but I didn't know he was a Dalit. You can't say that. Or if you want to say that, the accused has to prove. So it's a limited reversal of the burden of proof. Limited to the caste. Because in order to prove an offense, you must prove the caste. And you must prove knowledge of the caste. So now knowledge is assumed. You're from the same village. You know, obviously. And if you want to deny it, you must prove. So it's a very limited presumption. Guilt has to be proved by the prosecution. That remains the same. That has not changed.
Sir, you wanted to...
I want to spend some time on removing this panic.
Yes, sir.
That burden of proof has been shifted. Burden of proving the crime and the accused is the criminal. That burden has shifted. This is not true. The basic tenet of our jurisprudence, that it is the duty of the prosecution to prove that a crime took place and the person accused is the person who committed the crime remains as it is.
Correct.
The Evidence Act, Section 114, contains certain presumptions. All these presumptions apply. Plus, special acts have got depending on their nature. For example, Prevention of Corruption Act provides a presumption that if you have property more than your known assets of income, then you are corrupt.
Correct.
Unless you prove to the contrary. Similarly, there are 3 presumptions, 2 old presumptions and 1 new presumption in this act. The new presumption is that because Section 325 deals with IPC offences of more than 10 years imprisonment, those cases if you committed, they also become atrocities. Their original act said, on the ground that he is an SC or ST, if this crime is committed. That has been changed into knowing that the victim is SC or ST. Now what is the meaning of knowing? There is a presumption that if you know the family
Then you
and
know
the
the caste.
individual, then Indian sixth sense is such that you smell the caste and you cannot say I did not know the caste. So
Yeah,
that
you want
presumption-
to add to that.
not really.
Very well explained, sir.
Well said, well said.
Very well said, sir.
Slightly different.
Yeah.
This whole thing about this act, wonderful act. Does the NDA government intend to implement? It does not intend to implement. Why do I say that? Supreme Court says when you make social legislation requiring courts, judges, lawyers, computers, infrastructure, offices, chairs and tables, you must provide in the financial memorandum how are you going to give the money for that. How much will this act involve? 10,000 crores, 30,000 crores? Look what the NDA government says. It says we cannot say how much money will be required for all these judges, infrastructure and so on. So in the financial memorandum, they make no allocation. Zero allocation for extra expenditure for this act. Therefore, wonderful act, but the NDA government has no intention of implementing this act. And all this talk of exclusive courts, exclusive public prosecutors and so on, I suspect that in a few months down the line, we will realize that the implementation of this act is also zero, unless the government allocates money for the implementation.
So the role of the state governments, let's suppose the point that he has made out.
Before I go to state government,
Yeah.
I would not blame a particular government. All governments in this country are yet to show seriousness about implementation, which means the Prime Minister of the country, irrespective of the party, past and present, Chief Minister of the state, irrespective of the party, have both show active interest. I have explained how they can show active interest. If they do that, the district will show interest, SP will show interest, the lawyer will show interest, judge, everybody will, down the
chain
line will fall in line. That is required. It is not the fault of one particular party or no, but unfortunately, I am not able to say this party or this person has shown consistent interest. That has not happened so far. Now, if things have to happen, apart from the interest of these people, we have to create proper systems and structures and persons. It is possible. How will this be done? This can be done only if, apart from the interest of the Prime Minister and the Chief Minister, if activists, lawyers, unfortunately, all this media is not available for the SCST.
Sir, the money allocation point that he made, in absence of that, how do you see the state governments implementing this? Because the responsibility is of the state.
Once the responsibility is, the center also has got responsibility.
No, that is also a state. I mean, state government, whether it's a center or a
Central
state,
government
is a
or state
state.
government, yes.
All I'm saying is, how do you see the state government trying to implement it
The funds
without
required,
allocation of funds?
The funds required can be provided if the share of the scheduled castes and scheduled tribes in the total plan is accepted by national policy but not properly implemented. 16% of the national plan resources must go to the scheduled castes, 8% must go to the scheduled tribes, and 7% in the states. There is another bill which is also ready, not implemented, not by India government alone. UPA government also did not do it. And that bill, if passed, it will make sure this money is kept aside. And if this money is there, there will be enough money for atrocities courts, there will be enough money for residential schools, enough money for land distribution, enough money for irrigation of the SC/ST lands.
You want to add anything?
I'll say something. This is the peculiar Indian phenomenon. Make a law, bluff the people, go abroad, tell the UN, bluff everybody, don't implement. It is the law enactment where right from the beginning you have no intention of implementing. This is the Indian system.
On that note,
Fooling
sir,
the people.
On that note, sir, moving on, my colleague Raj Kamal Rao spoke to Beena Lakshmi Nepram, social activist, and tried to get her perspective.
I think at the moment, it will be helpful when the people of Northeast come out from the Northeast into other metropolitan cities of India, like Delhi, where almost lakhs of population of Northeast are already there. In fact, in all the cases, whether it's Nidotanya, which even the court failed to mention that he was an SC/ST, and later it was added. Yes. So in all these cases, because majority of these young people fall in the SC/ST category, this particular piece of legislation was used in the filing of complaint, police FIR and other things. Even if it's there, it acts as a deterrent, but it hasn't helped in resolving crimes and racial violence against Northeast people, number one. So as I said, in Delhi NCR and other parts, this SC atrocities, act as of the earlier one has been sort of revoked in many of the cases.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.